Hey everyone, welcome to my podcast on Supreme Court WebQuest, a project dedicated to grade 12 law. I'll first introduce myself before I discuss the court case I have chosen. So, my name is Remjin D. Craft, and I am a 17-year-old Filipino teenager from New York City. When I first moved to the United States in 2024 during my junior year, I was fully exposed to a curriculum that studies the history of the United States, encompassing British rule, the American Revolution, the Civil War, the Industrial Era, women's suffrage, African American history, the Great Depression, the Cold War, and several current events such as the September 11 attacks and the COVID 19 pandemic. Today, I'll be talking about a current Supreme Court case involving the 14th Amendment on due process and the First Amendment's protections for freedom of speech and expression. Before I reveal the name, I have an interest in this court case because its outcome could disrupt a student's identity or infringe upon their rights when school staff change names or pronouns without parental consent. I was searching the news on YouTube, and here's what it played.
Gianna, thanks. We're following developing news out of Ludlow, a federal lawsuit filed by four parents against school officials and staff at Baird Middle School for talking to their children about their gender identities without their parents' consent.
When I wrote my amicus curiae for my law project, I was referring to Foote v. Ludlow School Committee, a federal lawsuit that raised important constitutional questions about parental rights, student privacy, and school authority. The setting of this was Ludlow, Massachusetts, a small New England town located in Hampden County. It's only 10 miles from Springfield, Massachusetts, the city where basketball was first invented in December 1891 by Dr. James Naismith, a physical education instructor at Springfield College. The constitutional issue centers on whether a public school violates constitutional rights by allowing students to use different names or pronouns without their parents' knowledge or consent. It all started in April 2022. Stephen Foote and Marisa Silvestri were the petitioners who discovered that public school staff allowed children to use names and pronouns in support of a student's gender identity without parental consent. Essentially, the school acted under a district policy to protect student privacy, but the parents challenged it, arguing that it violated their parental rights and responsibilities. The Ludlow School Committee refuted this argument, stating that the policy provides a safer environment for all students, regardless of gender or sexuality. At first, the federal district court dismissed the lawsuit, ruling that the policy of the Ludlow Board of Education did not violate fundamental rights. In February 2025, the United States Court of Appeals for the First Circuit upheld the dismissal, noting that the parents failed to provide sufficient evidence to fully prove that the school's social transition protocol violated their constitutional rights. Since I completed my amicus curiae project months ago, I recently discovered that the US Supreme Court denied certiorari on April 20th, 2026, which left the First Circuit's decision in place. The Foote v. Ludlow School Committee lawsuit raises a debate over whether parents who raise their children, give them their names, and teach them societal values should have the primary authority over decisions involving their children, or whether schools should prioritize the safety and well being of students who may not feel safe expressing their gender identity. The petitioners argued that public school staff distorted parental responsibilities by allowing students to adopt distinct pronouns and nicknames without informing their families. As a result, Stephen Foote and his wife claimed that Ludlow's school policy inhibited their ability to discipline their children or direct the education and the well being of their children. This debate is centered around the 14th Amendment, specifically the Due Process Clause. According to the US Constitution, state and local governments cannot deprive anyone of life, liberty, or property without due process. So, what is due process? It's like a promise granted by the government that it must act fairly and respect all legal rights when depriving someone of life. That means the government must follow fair procedures and respect certain fundamental rights before interfering with an individual's liberty. Courts have used this clause to protect parental rights, and that includes Stephen Foote's family. They have the ability to provide education and care for their children. Therefore, the petitioners argued that Ludlow's policy concealed information from parents and prevented them from playing a role in important decisions regarding their children's moral development. Supporters of the Ludlow School Committee disagreed and believed that schools have a responsibility to provide a safe and supportive environment for all students, allowing them to use preferred pronouns or names to protect student privacy and minimize discrimination or emotional harm. School staff believed that the policy was intended to support the growth, development, and well being of students, not inhibit parental authority. If we take a closer look at these arguments, the constitutional issue also involves the First Amendment, which protects freedom of speech and expression. The parents view students' names and pronouns as a form of personal identification. Because the school committee failed to inform families about this policy, it prevented parents from being involved in decisions regarding their children's self expression and development. Again, the Ludlow School Committee disagreed, stating that students can use their preferred names or pronouns to freely express their identity in a safe educational environment. Therefore, the constitutional debate is centered on whether parental authority should be involved in these decisions or whether schools may implement policies to protect student privacy and identity while at school. Now that the Supreme Court has denied certiorari, Public schools within the First Circuit are not required to notify parents when students request different names or pronouns at school. Henceforth, the ruling encourages some school districts to continue adopting policies that prioritize student privacy and identity. The decision may also affect parental rights because some parents may argue that they have less involvement with their children's education and well being. Others may view this ruling as a limitation on parental authority because schools may avoid disclosing information that families consider important. Fortunately, for some students, this ruling may provide greater privacy protections in terms of identity, especially those who are not comfortable discussing their identity at home. Supporters of the Ludlow School Committee policy point out the protection it offers in creating a safer and more supportive educational environment. On the other hand, critics may argue that excluding parents from these discussions weaken family ties and communication, while potentially impacting a student's mental health due to discrimination, name calling, or verbal bullying. Because the Supreme Court refused to hear the case, other states and local school districts may adopt different policies across the country. Some states may require parental notification and involvement in their children's affairs, while others may continue to withhold a student's confidentiality. As of today, the issue remains unresolved and may create future legal challenges involving constitutional rights and public education. To summarize everything, Foote v. Ludlow School Committee highlights the ongoing debate between parental rights, student privacy, and school authority. Supporters of parental involvement argue that if schools do not function properly, they may disrupt students' identities, which could lead to psychological stress or hinder healthy development and motivation to attend school. Therefore, educational institutions must balance their role in student development with respect for both individual rights and family involvement. Similarly, policies that limit a student's control over their identity may produce similar psychological effects that the court sought to prevent in Brown v. Board of Education. Schools must remain aligned with their goals to provide education for their students, while also avoiding interference with a child's identity development. Therefore, parents can remain responsible and provide the support that their child needs to ensure that they preserve their image and be proud of their identity, name, and willingness to express themselves without solely relying on the school's regulations. Finally, the Constitution requires that any state action affecting a student's identity or family structure must be carefully justified, as policies that bypass parental involvement may risk individual liberty and other constitutional protections under the 14th Amendment. At the same time, Supporters of the Ludlow School Committee argue that schools have a responsibility to provide a safe and supportive environment for students who may not feel comfortable expressing their identity at home. Cases like Foote v. Ludlow School Committee will likely remain important in sharing future discussions about constitutional rights and public education. Well, that wraps up my podcast. I have given you my perspective on this lawsuit. Thanks for tuning in. If you would like to listen to my other podcasts, such as the Double Attraction Paradox or the Woodside Tenants podcast, you may scroll down to the In This Episode section to find those podcasts. Once again, thanks for listening and have a great day.